Good day. We're back again with chapter 3, and we're going to be looking at classifications of the law in general. Now, let's begin. This whole concept of the classification of law was a tradition started by the Romans of classifying the law into different disciplines or branches. So there is no perfect or ideal way to classify the law. There is no concrete tree or outline wherein you classify the law in the most perfect way into its perfect branches and so forth. We can only lay out the different classifications of the law. Now, writers also differ among themselves as to where some branches of the law fit into the whole classification. So, we might get into the whole argument, but we do not have such time. We can only look at the classifications that were laid down by Maduku, and also the others that were laid down in the book that we refer to, The Beginner's Guide to a Law Student. Now let's continue. So the first classification that we have international law versus national law. Now, what do we mean by public international law? These are the laws that are binding on relations between states. Right? There is no international law that all states have to. There is no international world organization, that lays down all the rules of all the states in the whole world. There is no such rule. Rules are created by international customs, international treaties and conventions, and those that are signatories to such treaties and conventions are the ones that are bound by them or that adhere to them, not necessarily bound. So treaties can be between two states, two or more states, or several treaties between international organizations, and anyone who violates them would be held accountable by the International Court of Justice, the UN. But a state cannot be compelled to appear in the court. So it is really I don't know how such an enforcement would be regarded as such if you can choose not to appear, but that is the case and that is what is there. Now, international law covers a whole lot of areas, wide range of areas. We have diplomatic relations, air traffic between states, principles of human rights, the conduct of war, and so forth. Now, international law, in terms of our constitution, when it's incorporated into national legislation, right, when it is ratified, that's when it now applies into national law. Rules of international law are automatically part of our national law as long as they are not in conflict with the statutes and in conflict with constitution, right? And they are not in conflict with statutes or common law. When interpreting the Bill of Rights, a court must have regard to international law. We know the relevant section for that one. Now, in terms of national law, there is the obvious one. This is the law that is specific to a country. In this case, the law specific in Zimbabwe. It means the whole body of legal rules that apply to Zimbabwe. With reference to our previous chapter that we talked about on the sources of law, that is the national law of Zimbabwe. Now, it is important for us to differentiate between public international law and private international law. Private international law is referred to also as the conflict of laws, wherein there are private individuals from 2-3 different countries that want their dispute to be heard or that have an altercation. They need to decide which law applies to those 3 individuals from 3 different states Such a conflict is referred to as private international law. For example, when X comes from Botswana, P comes from South Africa, Q comes from Zimbabwe, they contract in Canada. To see what country applies to that dispute, we have to apply private international law, which is the conflict of laws. It decides which law would apply in those rare situations. We talked about this. This happens when there is some connection between the parties, facts of a case, and there is some foreign legal system that is there. I gave an example there. A Zimbabwean woman and a Russian man got married in New York, and they have been living in Harare for 15 years. They want to get divorced. Such a conflict is what is private international law. Now, another classification of law that is worth noting as a differentiation between criminal law and civil law. Civil law being the form of private law that involves relationship between individuals. We talked about the horizontal relationship. Two individuals have a dispute or are contracting, or they are regulating their conduct. That is civil law. Now, according to Madruku, the main objective of civil law is to compensate the victim for the harm suffered. And then we have examples of civil wrongs like breach of contracts, delicts, invasion of privacy under delict, defamation. So when we're talking about assaults now, right, an example that is an overlap between criminal law and civil law, but we'll talk about that one later. In a civil case, the liability of the other party need only be proved on a balance of probabilities. Now we're talking about the standard of proof. We're going to go into detail on that one on the foregoing passages. Now we have criminal law. This now revolves around a vertical relationship between a state and its individuals. It is public law and refers to conduct which the state considers with disapproval and which it seeks to control, or involves the enforcement of human conduct. We noted this on our first chapter when we're talking about what is law and so forth. And we referred to law, the purpose of it. We referred to Thomas Hobbes and how they referred to the law as a social contract between individuals and the state. A contract being that the state should protect its individuals, protect its rights, and so forth. So now criminal law comes in with that very aspect in mind. The state now comes in and enforces the law that it has created to regulate human conduct. Now, the main objective of criminal law is punishment of the offender. A crime is a wrong punishable by the state, and a criminal case, that's when a criminal case would be referred to as state versus whoever the accused is, because the state would be the prosecutor that is prosecuting the accused, will be representing the state. The state will be also representing on behalf of the community that has been wronged by whatever social misnomer that has been done by the accused. Now, let's continue on. We talked about this. The standard of proof is different between criminal and civil cases. Criminal cases, it is beyond reasonable doubt, and in civil cases, it is on a balance of probabilities. Now, in terms of criminal cases, beyond reasonable doubt is different from beyond a shadow of a doubt, because doubt will always be there, but we want it to be a reasonable doubt. Beyond that, beyond the reasonable doubt, beyond a shadow of a doubt is hard to really achieve. A person can never be 100% sure, but we want to achieve the 99% or the 98% in order to accuse someone. Now, the guilt of the accused must be overwhelming in such a way that any doubt that may still exist must be unreasonable. That is a perfect way to sum up the standard of proof. Now, on a balance of probabilities, that means that chances are that the allegations are true should be above the 50% line. If you can prove that there's an above 50% chance, there's a 60% chance that the allegations that I am that you'll be proposing to in court are true, then you are good to go. Now, a person found guilty beyond a reasonable doubt is clearly liable, obviously on a balance of probabilities. Now, as we continue on, we have the Zesa versus Dera. It sums up the rationale behind the differentiation of those two standards of proof that we talked about. The rationale being that in terms of a criminal case or a criminal trial, it is beyond reasonable doubt because the outcome of such cases are dire. We are talking about infringing a person's freedom of movement, and in some cases the right to life in death sentence cases. So we want to have beyond a reasonable doubt assurance that the person is indeed guilty, as opposed to civil cases wherein the offense only would result in monetary loss, right? So on a balance of probabilities, you can prove your case and the person loses a few dollars or so. So that is the rationale behind that. Now, in terms of substantive and procedural law, this classification, straightforward stuff. Substantive law, we are talking about material law. We'll be looking at what is the law, what doesn't it tell, what is the content of the law, what are the rights that you're going to enforce. So for us to know the content of law and so forth, we'll be looking at substantive law. This is your criminal law, your law of contracts, law of obligations. That is substantive law. Now, as opposed to procedural law now, it determines the way a case must be practically handled, right? We are looking at the procedure now. How do we now enforce the substantive law that we now know? You realize that you have a contractual right, in terms of the law of contract. How do you now proceed to enforce that right in court? This is now the how part. So that is procedural law. It involves the law of evidence. It involves civil law procedure, criminal law procedure, and how we are going to enforce the rules that you have realized. Okay, now we are off to public and private law, the differentiation between the two. Public law, it relates to the vertical relationship that I was talking about. We are talking about the extent of state authority. It regulates organs of the state, regulates relationship between different organs, regulates relationship between states and its subjects. So this is the vertical relationship that I was talking about. It covers constitutional law, administrative law, criminal law, and so forth. As opposed to private law now, private law comes in and regulates relationship between individuals. The legal subject It determines the different rights and duties that each person may have, and these rights and duties may originate from contract law, the family law, and so forth. And so forth. So the main branches of private law are we have property law, the law of persons, family law, law of obligations, going forth. But the state may also be party to areas of private law, for example, when it enters into a contract with individuals, right? In this case, the state does not act with state authority but acts in the same position as other persons. Rights under private law are enforced through the law of civil procedure. We have the distinction between public law and private law is not fixed. There are areas that may overlap, let's say in labor law, registrations and regulations of trade unions largely fall under public law, while the relationship between the employer and employee are under private law. So these are the divisions of adjective law. We have criminal procedure, which notes how people should be prosecuted. And then we have civil procedure, which knows the procedure for individual enforcement of rights. And then we have the law of evidence, how facts in court must be proved. It gives us the evidentiary know-hows of court. And then we have the legal interpretations. It tells us the rules that govern how meanings of statutes are determined. So this is adjective law or procedural law. Now, the divisions of private law now come in. We are looking at the law of persons. We are looking at the person's legal standing in law. We are looking at family law, property law, straightforward stuff, regulating family relations under family law. And then we have the law of obligations subdivided into contract law and the law of delict, the obligations that parties give each other or imposed in terms of the law of delict. These the law of obligations, we have law of contracts, law of delict, an example of the textbooks. So the laws of obligations, I kept repeating that. And then these are the classifications of the law. If you have any questions and so forth, you know the consultation hours, you know my email. We'll talk to you in class.